Supreme Court nominee Ketanji Brown Jackson getting into it a bit today with Senators Ted Cruz and Lindsey Graham, asking her about critical race theory, the definition of women, and asking about predators and her time as a defense attorney. Let's take a listen to see what Ted Cruz said when he opened this, hearkening back to the time when Ted and Ketanji were old pals at Harvard.
Thank you, Mr. Chairman.
Thank you,
Judge
Ted.
Jackson, welcome.
Thank you.
Congratulations.
Thank you.
You and I have known each other a long time.
We have.
We went to law school together. We were on
this.
the law review together. We were a year apart.
Happily so, I hope, Senator.
We were not particularly close, but we were always friendly and cordial.
Now, she was trying to be extra friendly, and he kind of was like, yeah. Keep your smiles and your laughs and your jokes to yourself. We're not that friendly here. You're the enemy today.
We were.
So Ted Cruz and Ketanji Brown Jackson, two peas in a pod over there at Harvard, just spending time together on law review, talking about solving the world's problems from other sides of the political aisle. Isn't it beautiful? Now here they are running the governments, and we're going to see more from them. The next question from Ted is about the 1619 Project. He's referencing a woman that Ketanji Brown Jackson referenced in a speech that she was giving, saying, do you sort of endorse this woman's idea from this project, saying that colonists, that one of the reasons they wanted to leave England and the old world to come to the new world was because they wanted to preserve slavery. They weren't trying to escape it. In fact, they wanted to sort of rebuild it here in bigger and better ways. Do you support that? Do you say that all of the founders were racist here, Ketanji?
Do you agree with Miss Hannah Jones that one of the primary reasons the colonists decided to declare independence is because they wanted to protect the institution of slavery?
Thank you, Senator. When I gave that speech at the University of Michigan, I was asked to speak on Martin Luther King Day. And every year they have a Martin Luther King Day speaker. And I gave a speech about Black women in the civil rights movement. Most of the speech, if not all of the speech, was focused on African-American women, their contributions to the civil rights movement, unsung contributions in many cases, and then some of the more recent African-American women who have made claims, who have done things in our society. One slide was of Ms. A journalist, as you say, who made that statement, and I called it provocative. It is not something that I've studied. It doesn't come up in my work. I was mentioning it because it was, at least at that time, something that was talked about and well known to the students that I was speaking to at the law school.
Okay, so I think I see what she's saying. I think she's trying to explain that the speech that she was giving was sort of a mashup, a smorgasbord of all the different theories or ideologies or different interpretations or cultural perspectives that maybe were being observed out there in society. And she was just kind of going, and here's this person who has this idea, and here's this person who has this idea, and this person this idea, but not necessarily endorsing any particular idea, just saying that every one of these is relevant to the conversation that they're having in colleges and on campuses throughout the country. So this is part of the conversation that she is having, and she's answering Ted Cruz's question, just saying that it was just one small snippet of a much broader conversation. Ted Cruz finishes the question and really drives his point home.
So are you aware that since the 1619 Project came out, that it has been roundly refuted by very respected historians, including Gordon Wood of Brown University, including James McPherson.
Do you know that?
Of Princeton University. McPherson called it a, quote, very unbalanced, one-sided account which lacks content and perspective. And indeed, it was so thoroughly refuted that the New York Times quietly altered the digital version to remove references to 1619 as the year of America's true founding and the moment America began.
Did you know this, Judge?
Were you aware of that?
I was not.
Great question there, Ted. Good question. Yes or no question? No, I wasn't aware of that. Any follow-up? So we see some of this. Now, why is Ted Cruz doing this? Why are the Republicans doing this? Two reasons, I think. One, of course, is political. They're going after some of the political hot button issues, things like critical race theory, things like gender identity. We're going to hear more of that as this comes to pass, but we're also thinking that Ted Cruz is wanting to see if he can help adjust this judge's future policy positions. Say, let me educate you a little bit. Some of these things that you may have heard about, they're actually pretty dumb. A lot of people that you may know and respect all think that these are bad ideas. And so I'm just trying to educate you before you get on the bench, because I think they know at this point, it's probably a foregone conclusion. They may even vote for her, that she gets on the bench, but they're going to try to see if they can help maneuver, modify some of her political positions before she gets on there. And so you can see that's where some of these questions are going. That's why they are geared the way they are. We have another question here coming in about critical race theory from Ted Cruz, seeing again that he is going to be really pointing on this political hot button issue. Instead of asking things about judicial philosophy, sort of asking about, well, how would you sort of rule on these things if you are on the Supreme Court? This is what Ted Cruz says.
So, Judge Jackson, all of us will agree that no one should be discriminated against because of race. When you just testified a minute ago that you didn't know if critical race theory was taught in K through 12, I will confess I find that statement a little hard to reconcile with the public record, because if you look at the Georgetown Day School's curriculum, it is filled and overflowing with critical race theory.
Okay.
That among the books that are either assigned or recommended, they include Critical Race Theory, an introduction. They include...
Do you have a question?
The End of Policing, an advocacy for abolishing police.
Did she write that book?
They include How to Be an Anti-Racist by Ibram Kendi. They include literally stacks and stacks of books, and I'll tell you two of the ones that were most stunning. They include a book called Anti-Racist Baby by Ibram Kendi. And there are portions of this book that I find really quite remarkable. One portion of the book says babies are taught to be racist or anti-racist. There is no neutrality. Another portion of the book, they recommend to babies confess when being racist. Now, this is a book that is taught at Georgetown Day School to students in pre-K through second grade, so 4 through 7 years old.
All right.
Do you agree with this book that is being taught with kids that babies are racist?
Senator,
come on.
I do not believe that any child should be made to feel as though they are racist, or though they are not valued, or though they are less than, that they are victims, that they are oppressors. I don't believe in any of that. But what I will say is that when you asked me whether or not this was taught in schools, critical race theory, my understanding is that critical race theory as an academic theory is taught in law schools, and to the extent that you were asking the question, I understood you to be addressing public schools. Georgetown Day School, just like the religious school that Justice Barrett was on the board of, is a private school.
Okay, so you agree critical race theory is taught at Georgetown Day School?
I don't know, because the board is not, the board does not control the curriculum. The board does not focus on that. That's not what we do as board members. So I'm actually not sure.
Well, and I'll note that the board is chaired by Professor Fairfax, your college roommate who introduced you yesterday. So the two of you serve on the board together. Another book that is on the
so I think it's just guilt by association.
Is a book called Stamped for Kids, again by Ibram Kendi. I read the entirety of the book, and I will say it is an astonishing book. On page 33, it asks the question,
did she write it?
Can we send white people back to Europe? That's on 33. That's what's being given to 8 and 9 years old. It also, on page 115, says the idea that we should pretend not to see racism is connected to the idea that we should pretend not to see color. It's called color blindness. Skipping ahead, here's what's wrong with this. It's ridiculous. Skin color is something we all absolutely see. Skipping ahead, so to pretend not to see color is pretty convenient. if you don't actually
Do you have a
want to stamp
question?
out racism in the first place.
What's
Now,
your
what this
question?
book argues for is the exact opposite of what Dr. King spoke about on the floor of the Lincoln Memorial.
What's your question?
And are you comfortable with these ideas being taught to children? As
Is that
young
a
as
legal-
4 in respect to the first book?
Is that a
as young as
legal
8 to 9
question?
in respect to the second book?
Idiots?
Senator, I have not reviewed any of those books, any of those ideas. They don't come up in my work as a judge,
Obviously.
which I'm respectfully here
Stupid moron.
to address in
She's
my
right.
work as a judge, which is evidenced
Ugh,
from my near decade on the bench.
the dumbest people
I
in
am-
charge.
Then let's go back to your work as a judge.
Yeah, let's go back to it, idiot. All right, so here's Ted Cruz. Pulls out his whiteboard now to illustrate how in CP cases, Ketanji Brown, oh, look, we have some actual legal questions. So then Ted Cruz decides to ask an actual substantive question. He pulls out his whiteboard, according to Greg Price on Twitter, says that he's going to illustrate how Ketanji Brown gave defendants an average of 47.2% less sentence than what the prosecutors recommended. Now, this is a little bit interesting. Let's break this down.
Let's look at what the prosecutors are asking for. And I would note that this was in the District of Columbia, where prosecutors are far more liberal than many of the prosecutors in this country. And in every case in which, so United States versus Hess, there was a mandatory statutory minimum of 60 months, and you imposed 60 months because you had no discretion. In United States versus Nickerson, there was a mutual agreement of the parties to 120 months, and that's what you imposed. In every other case, United States versus Chazen, the prosecutor asked for 78 to 97 months. You imposed 28 months. 28 months is a 64% reduction.
He's missing
In
a
United
column.
States versus Cooper, the prosecutor asked for 72 months. You
This guy
imposed
is,
60 months.
he's missing a whole column. Okay, so let me explain how this works. This is ridiculous. So we have a sentencing guideline, which is just a standard sort of set guideline that's in a big manual. We talked about that previously. It's 608 pages. We know the government's recommendation is going to be from a prosecutor. Okay, that is from the government. Now, many people like Ted Cruz claim to be small government people until they talk about the military and the police, and suddenly they're for warrantless entry by anybody with a badge. So it gets a little bit irritating when they only represent the government and they stop representing individuals, defendants, people who are presumed innocent in this country. There is an entire column missing here for defendants. Defendants also have rights in this country. They're also presumed innocent. And so we don't just listen to the government's recommendation here. We don't listen only to one side of this equation, the government's recommendation. We also have an entire column. It's blank here. Maybe he actually blanked it out. But there should be a defense recommendation where the defense makes their pitch, where they say, hey, according to the sentencing guidelines, we have found there's a whole slew of mitigating factors here that justify a downward departure, that justify a deviation. And so you might see here the government's recommending 60 months. The defense is recommending 0 months, for example, because they think that there is a justification for it. So just because the judge is making sort of splitting it down the middle or finding a medium, a middle ground there in between the prosecution recommendation and the defense recommendation doesn't mean that this judge is suddenly sort of deviating away from the prosecution. What this is presuming is that she should be just falling in line with what the government recommends every single time. He's saying that she is deviating from the prosecution's recommendation a certain percentage of the time, which is good. Because if she was always siding with the prosecution, that would mean that she was a biased judge. She's got to go and find the middle ground between what the defense recommends and what the prosecution recommends. And so dishonest Ted Cruz here, Lion Ted, is leaving an entire column off of this chart.
Reduction. In United States versus Downs, the prosecutor asked for 70 months. You imposed 60.
What did the defense ask for?
14%
Maybe
reduction.
maybe the defense asked for 40 months. Okay, maybe they asked for 40 months and she gave him 60. So she's actually sort of representing, getting closer to what the government is recommending. Maybe there's more justifications for downward deviations than what the sentencing guidelines are imposing, and she's departing downward. So maybe she didn't go as far as the defense wanted, and she could have. but they're leaving that recommendation off. What's the defense?
United States versus Hawkins, the prosecutor asked for 24 months. You imposed 3 months.
Okay, so what did the defense ask for? 0?
88% reduction.
Yeah,
in United States.
And you can see there is a big deviation there, right? Okay, if the sentencing guideline says 97 to 121 and the government themselves are asking for 24 months, okay, you can see there's a big, gigantic disconnect here. This case is obviously a case where even the government's like, look, the sentencing guidelines here is whacked. This is ridiculous. Whatever happened with this individual is like, all right, it's really bad, but it's not what the sentencing guidelines anticipated. That's why they're willing to go down to 24 months. So don't act like the 3 months coming down from the 97 or the 121 is the proper remedy there. The government is agreeing that a departure is justified. Lion Ted.
Versus Savage, the prosecutor asked for 49 months. You imposed 37. That was a 24%.
What did the defense recommend?
United States versus Stewart, the prosecutor asked for 97 months. You imposed 57. That was a 41% reduction.
This liar, a reduction from the government's request. That's not the baseline. They don't get to start where the discussion happens. Crackhead Ted.
Single case, 100% of them, when prosecutors came before you with child pornography cases, you sentenced the
She doesn't work for the prosecutor's office. They don't get to decide the baseline.
Defenders to substantially below, not just the guidelines, which are way higher, but what the prosecutor asked for on average of these cases, 47.2% less.
I think this actually justifies her. Basically, every one of these cases, if the prosecutors themselves are willing to come way down off of the guidelines, according to Ted's logic, he's saying they're coming down even further than the guidelines were for the original charges. That means they're looking at their cases and they're saying these are weak, terrible cases that justify a departure from the sentencing guidelines. And so the fact that she would take a look at that and say, hey, look, even the prosecutors think that this is justifiable for a reduction. Maybe she's looking at the defense mitigation, finding a mountain of support there, and then actually making the reduction and the departure. I don't know these cases. I haven't looked into any of them, but I'm going to guess that they're probably some cases that are highly justifiable. Now we have Ketanji answering these questions, responding to a lot of the criticism about some of these sentences that many people, in my opinion, have distorted. Let's listen to how she explains it.
We are going to treat a person who's distributed 1,000 a lot worse, because that shows that this person is really engaged in this really horrible behavior. In comes the internet. On the internet, with one click, you can receive, you can distribute tens of thousands. You can be doing this for 15 minutes, and all of a sudden, you are looking at 30, 40, 50 years in prison.
Good.
Good. I understand.
Absolutely
Senator,
good. I hope you are. Good.
Allow her to finish, please.
I hope you go to jail for 50 years if you're on the internet trolling for images of children and sexual exploitation. So you don't think that's a bad thing? I think that's a horrible thing.
That's not what the witness said, and she should be allowed to answer this question once and for all. Senator.
Yeah, that's actually not what she was saying, but there are consequences, of course, for these types of activities. The point that she was making, I think, was that oftentimes people will sort of get gigantic batches of data. They'll go to one location, they'll download, a 5 gigabyte file. Within that file, buried within there may be some offending images that are highly problematic. In Arizona, for example, we have laws that say 10 years per image, 10 years per image. So if somebody comes and shows up with 5 or 6 images, that's 50, 60 years instantly. And if that happens to be in a big, gigantic batch with other images that are not illegal, and it comes upon somebody's computer because they were poking around one night, that's the situation that Ketanji was talking about. As horrendous as it is different than a situation that she was describing whereby an individual is out there actively seeking and organizing their file folders and distributing these things and gobbling up there and sort of being a part of the distribution pipeline. It's a different situation that, although both are problematic, require different outcomes and different interpretations through our justice system. Lindsey Graham is somebody who just doesn't, I guess, think about those things, can't see different shades of the colors. Literally everything is just black or white. If somebody does something, there's no reason to talk about it. Maybe he wants to get rid of due process and jurors and the presumption of innocence, or I guess justice in our justice system. Because what we often try to do is rehabilitate people, make people recognize the erroneous ways that cause their criminality and help them get back onto a righteous path where they can redeem themselves and come out a more productive, useful person after the justice system. Not just saying, well, sorry, I mean, you had a bad night, you're 18 years old. All right, well, 120 years, you're dead now. Good luck. Bye. Apparently, Lindsey Graham is that type of, oh, good, right? He's that type of person who doesn't want to take a look at an individual case and distinguish between the people who are the actual monsters and the other people who are worthy of some humanity and some grace. Lindsey Graham, though, I'm not sure is too consequential or too maybe in tune with some of those concepts. But weirdly, we have some Democrats, I can't believe I'm saying this, who are actually, standing up for this judge, who I think is on the right side of this issue, saying that your nomination has turned into a testing ground for bizarre conspiracy theories. Although I don't know what he's talking about. Let's critique this here.
I would say that the bottom line is this. You have done what 80% of the judges have done. You're in the mainstream of sentencing when it comes to child pornography cases. I also think it's ironic that the senator from Missouri who unleashed this discredited attack refuses to acknowledge that his own choice for federal judge in the Eastern District of Missouri has done exactly what you did. You also have been criticized as having been wrong to be a public defender or even to be in a law firm representing a Guantanamo detainee. It's interesting that Republican judges, very conservative ones, don't see this as a blemish on your character. They understand, as we do, that the Sixth Amendment creates a responsibility that people have a right to counsel.
That's right.
You have exercised that responsibility in your professional life. This, incidentally, yesterday, your nomination turned out to be a testing ground for conspiracy theories and culture war theories.
Not sure I'd call them conspiracy theories, but I do think that what he's referencing is Hawley saying that his judge, somebody that he would prefer for nomination or to be a part of the Supreme Court, if he was sentencing people in your same position, you'd see that he has a same type of percentage. Okay, and this is the bell curve that we talked about in the prior video, right? Judges, some sentences are going to be very harsh. Some sentences are going to be very lenient, but probably the majority of them are going to be kind of in the bell curve, in the meaty part of the curve that are sort of in conformity with the other judges. And what you do is you take a look and you say, well, how many cases are within that meaty curve and how many are sort of abnormalities or stand out from the rest? And you identify those and see this judge is sort of unlike the others. But what they're doing, in my humble opinion, what we can see from their presentation has largely been picking out a handful of cases, saying they don't like the sentences in those cases, and then holding those sentences against Ketanji. And you could go through that same process with any other judge. With any other judge that the Republicans put up, you could easily just go through their record, find a litany of cases that they disagree with, and say, on this one, I just don't like how this sounds politically. So it may be useful from a political perspective for senators like Graham and Hawley and Cruz to make this into a big deal, but it's just not really abnormal. I mean, this is just how judges operate. And everything that I have seen from Ketanji has shown that she's sort of done a pretty good job of trying to empathize with everybody who's involved in the situation, including the defendant. We know that Graham, though, is also upset about illegal immigration, saying he's concerned now about whether or not they should be allowed to vote. And her answer here is pretty much in line with the law because she's a judge and she's supposed to apply the law as written. Now, once this lands on her desk, when she is on the Supreme Court, and I'm presuming she gets there, she does get there. We may see how this changes when she is deciding these issues in a short while. This is from Graham.
Do you believe illegal immigrants should be allowed to vote, Judge Jackson?
Okay. Would like
Thank
a little
you,
bit
Senator.
more legal there.
Under our laws, you have to be a citizen of the United States in order to vote.
So the answer there is
So
no.
the answer would be no.
So not a good question
It's not
again.
consistent with our laws, so the answer is no.
Yeah.
Okay, why do they do that in New York?
Don't know. Does she run New York?
Senator, I'm not aware of the circumstances.
Okay. All right. Well, that's a good answer. The
Yeah.
answer is no.
So mostly nonsense questions, things that are targeting the political sound bites that they can take back home to their constituents and show them and say, hey, look, we're fighting Joe Biden and his judges or whatever. But I would have liked and appreciated some more substantive questions, things that really would have dived into this woman's judicial philosophy and required her to sort of peel the layers of the onion back. Most of these questions were not even questions. They were just largely speeches that then sort of intertwined some issues, probably because these judges kind of want her in there, right? They're all part of the same club. I mean, Ted Cruz went to Harvard with her. They were on law review. They probably had lunch together. So not really going to be much of an inquisition there. It's going to just be kind of a couple of the regular questions you might get with the regular answers you expect. And we'll see where this goes. Let me know what you think about this down in the comments below. Don't forget to subscribe before you get out of here. And I look forward to seeing you on the next one.